Yes, good evening to the aspirants of the PGLCET 2022 conducted with Osmani University. Karibu sana. Welcome to my online class today. And today, the second part, the end part of the jurisprudence multiple choice question I am going to deal today. Yes, what I posted on the screen, anybody will tell me? Read.
Good evening, Namaskar, Assalamu alaikum. Professor Dr. Mohammed Saheb Hussain, Professional of Law School of Law, University of Tanzania.
Tanzania.
Tanzania. It
Okay, that
is
much
read
is
in
enough. So,
English.
okay, what the photo conveys? The image conveys?
Key is there, sir, in your hand.
Yes, what it convey? Idea.
Yeah. Every lock has a key.
The image will
It is
convey
problematic.
that she is going to give the key to you. That is said to be a constructive proposition.
Sir, your voice is breaking.
Yes, now I will third this one because net is not that I am using the mobile data. Yes, this is the key which is giving is there. It is the idea is it is a constructive position. So now let us, without wasting the time, let us come to our point of our study. Yes, yesterday up to the 43 question that we did it, and next 44th question. Jurisprudence has given rise to several debates with regard to the nature of jurisprudence as the dash, vis its nature as dash. Option A, philosophy and art. B, science and philosophy. C, art and philosophy. D, philosophy and science. Shoot.
And science.
Repeat.
D. Philosophy and science.
Run. Here in this context, they say regard to the nature of the jurisprudence as a, number one, they say philosophy, it's good. Vis its nature as, what is the nature? As art. A-R-T, art. That is the right answer. Means A is the right answer. The first one, philosophy and art is the right answer. In this juncture, actually jurisprudence is a philosophy, it is a science, it is a skill, it is an art, it is a politics, it is economics, it is a mixture of all. Okay, next.
Okay, sir.
Can anyone unmute and read? What is the next 45th question? 45 question.
Dash on ownership denotes the relationship between a person and an object forming the subject matter of his ownership. Full stop. It consists in a complete of rights, comma, all of which are rights in rem, being good against the entire world and not merely against specific person.
Option A.
Option. Winfield, Field,
Winfield.
Hopes, HLA Hart, and D. Salmond.
Who said those words?
Salmon, sir. Option D.
It is a Salmond he said those words. The 45th question. An ownership denotes the relationship between a person and an object forming the subject matter of his own ownership. It consists in a complex of rights, all of which are the right in rem, being good against the entire world, not merely against the specific persons. When you are reading full stop, comma, you should not read. Only quotation when it comes. I quote, then the quotation ends, I unquote. That you have to read it. But the other things, either you can stop there and go ahead. But now I heard you read at least 2 or 3 punctuations. So that is not the way of reading. Is it clear?
Okay, sir. Yes,
Yeah,
sir.
I appreciate. I think that you take it a positive manner. 46th question.
Yes, sir.
Following are the important types of the position. One among them is not. A. Corporeal position. B. Uncorporeal position. C. Incorporeal position. D. Medieval position. Which one is the not connected with the
Op-
position?
Option D, sir. Immediate position.
Wrong.
C, sir, incorporeal position.
Wrong.
Option B, sir. Second one.
Second one, uncorporeal position is not there. If the incorporeal position is there, mediate position is there, corporeal position is there. And the 47th question. Following are the important types of position. Oh, your personal talk I could hear. Please mute. I don't know who kept it unmute. Let me check it. Yeah, Parshuram, mute. Durdana, mute when you speak at the time. And Sayyad, you also mute. When you speak, you unmute. Or if nobody is speaking or you are alone, okay, you can unmute and keep it ready. Okay? Shall I proceed? Parshuram,
Yes, sir. I'm
when
Yes,
you
sir.
want to speak, you can unmute it. Otherwise, you mute it. Or don't allow any other person in your house to talk. Is it clear? Say yes.
yes, sir.
Very good. I appreciate. So now next question is 47th question. Following are the important types of the position. Find the odd man out. Means 3 is belong to the type of position, 1 is not. A. Immediate position and constructive position. B. Adversarial position. C. Adverse position. C. De facto position and de jure position. Among the 4, which one is odd man out? Means not
Option B, sir.
B,
option.
second one, sir.
Option B, sir. B for bag.
Bank.
Yes.
B for bank.
Yes, there is no adversarial position is there. It is the adverse position is there, but not adversarial. Yes, the answer for the 47th question is B. The rest of the A, C, D are positions, important positions. Okay, now 48th question. The delivery of my key by my car driver. Here my driver was the dash, possessor of my car until the delivers me the key. Number A, mediate. B, immediate. C, constructive. D, actual.
Option D, sir. Actual.
Wrong. Just
Sir, it
in the
should be
beginning, I
B, sir.
told you, when I shown the image, and this image, when I shown you, I have given the explanation. The photo conveys it is a constructive position. Is it clear? So answer is
B, sir. Answer B. Immediate.
no. Constructive position.
I
C.
didn't get this one actually. Yeah.
Constructive position means it is given over there, not immediate. Is it immediate position? And he has given the key only.
Okay.
Is it immediate position? Not. Is it mediate position? Mediate position means he gives to mediator, mediator gives to somebody else. So there is a link would be there. And is it the actual position? Whether he has given the car? No, he has not given the car, but he has given the key.
Temporary. Okay.
Delivery of a key means constructive position.
Okay.
Yes,
Okay.
constructive means okay, now we can have the position of it. For instance, if you did not shift to the house, but you have taken the key, that gives the sense
Yes.
that it is a constructive position, though not is the actual position. Is it clear?
Yes, sir.
So
No, I
that
got
is
it.
the image I have shown over there to see. 49th question. Anyone can unmute and read?
Dash means the possession of some property or object without legal title for a certain time period sufficient to become acknowledged legal owner. Option A, de facto possession. Option B, de jure possession. Option C, adverse possession. Option D, none of the above. De facto, sir. Option is A, sir.
Do you know what is my de facto? In fact, it is true.
Temporary, sir, not a title owner.
Dash means the possession of some property or object without legal entity. There is no legal entity, legal title.
Yes, sir.
For a certain
Yes.
time period, you will keep it in your sufficient to become acknowledged legal owner. It gives a sense that you are a acknowledged legal owner. Unless until somebody will prove it, you are not the owner. You know,
Yes, sir.
our system of legal practice is there is the two systems are there administration when they are witnessing, when the cross-examining, when the trial is going on. In the civil law system, will follow the equatorial system. In the common law way, it is the person has to prove that he is a guilty. So that is the adversarial. So here the right answer is adverse possession. Unless until somebody will prove it that you are not the owner, then you deem that you are the owner. Is it clear? The answer for the 49th question is adverse
C, sir.
possession, not constructive
Okay.
possession, adversary.
Adverse, okay, sir.
Okay, now 50th question. Sometimes we also define adverse position informally as dash. Option A, squatter position. B, squatter obligation. C, squatter rights. D, squatter occupation.
Option A, sir.
Squatter possession,
Squatter's
sir.
possession.
It is the
A.
option A. People, those who are a little having the cyber knowledge, they could easily make it out. It is the squatter's position. Because this you could not find anywhere. These are all the things which with my mind, I coined them. I made them. You don't find it in the commercial books. Now let us comes to the fan. The right answer is squatter's position. The 50th
Yes,
question.
sir.
You know, in the cyber thought, there is a squatting, stalking, bullying or bullying, hacking, spam, phishing. These are all the very important terminology.
Yes, sir.
Okay, now let us come to the 52nd question. Yes. No, we did not read 51. For example, 51 question. For example, continuous use of private land or driveway or agriculture field for of an unused piece of land is known as dash or example of dash. I repeat, continuous use of private land or driveway or agriculture field of an unused piece of land is known as dash or are example of dash. Constructive position, immediate position, adverse position, none of the above.
Option A, sir. Constructive possession.
No, it is an adverse position.
Okay.
See, unless until somebody will make it out, you can enjoy the land. Means
Okay, sir.
he should be feel guilty, you should prove it. Up to the guilty will not prove it, he will be treated as innocent. It is merely the allegation. So adversarial system is there in our legal system. 52 question.
Yes.
Anyone can unmute and read?
Significance of jurisprudence are three, but not one. Find out. Option A, it gives a dimensional approach to the system of law. Option B, at times a huge gap is observed between the law and its application in the society. Option C, jurisprudence helps in such cases. Option D, it helps in bringing logic to the rules of law so that the application in society can be beneficial for the people.
Shoot, even though it is wrong, doesn't matter. There is no negative marks.
Sir, option D, sir?
No.
Option A, sir.
Yes, but you have to tell me the reason. You have to tell me the reason. A is the right answer. But I want the reason also.
It gives a
Jurisprudence
dimensional
is a
approach to the system.
multi-dimensional approach. I told you. Economic approach, political approach, art approach, skill approach, science approach, philosophy approach, psychological approach. So it is a multi. I removed the multi. Society can be beneficial for the people. It gives a multi-dimensional approach to the system of law. I removed the multi, I put the dimension. Yes, 53rd question. Dash considers jurisprudence as the lawless subject of law. I repeat, 53rd question. Considers jurisprudence as the lawless subject of law. Who said? A. Lord Atkin, B. Lord Denning, C. Lord William, D. Lord Tennyson.
Option C, sir, Lord William.
Wrong. Try. Second option.
Option D, sir.
Option D, sir. Lord Tennyson.
Lord Tennyson is the right answer. Lord Tennyson says, consider the jurisprudence as the lawless subject of law. Lord Tennyson, the D is the right answer for 53rd question. Now 54th question. The origin of jurisprudence is in the dash civilization. A. Babylonian, B. Greek, C. Roman, D. French.
Yeah, Greek, sir.
Repeat.
Greek. C. B, sir. Greek.
No.
Roman, sir.
It is
Option C.
Roman civilization. See, first civilization means Rome. Second, French. And after that one, it is the English colonial. See, if you compare it, I committed a mistake here. Can you tell me what is the mistake I committed here? If you just look at the screen, I committed some mistake over here. I want to observe that. Could you observe it or not? Did you observe it? Say pass on, I will give the answer.
Pass on, sir.
See, in the 53rd question, the options are capital A, capital B, capital C, capital D. But 54th question, say,
Small capitals, sir.
Small letters.
Small letters, yeah.
can't you observe it? See, it is easily visible to you.
What it signifies, sir?
I know, just I want to memorize, I want to see how much your quickness is there.
Okay.
Sharpness should be there.
We are finding about that question only, sir, not these options. We are concentrating on question only.
I want to see in which angle that you are receive my wordings. I told you on the screen, I committed a mistake. If you look at the screen, can you tell me that what mistake I committed? So anyway,
And one more mistake is there, sir. Means in the 53rd questions, there is no gap between the options.
Of course, that is also be because here 53 question starts with the blank and 54 question the blank is last but one. But the glaring mistake is small
Small
A,
letter,
B, C, D.
capital letter.
Yes, I want to see the glaring one. I want to see 2% I am making to stand over there. Tell me what is the difference between the two? Can you make it out? Or he is wearing the black shirt and she is wearing the black sari. You should say she is a female, she is a male. Okay, now next come to the 53rd question. Yeah, during the 17th century, the dash approach towards the law saw the light. A, natural. B, positive. C, historical. D, none of the above. In the 17th century,
Natural.
Positive, sir.
it is
Option
a
B.
positive approach is there in the 17th century. So now 56th question. Different approaches toward the study of jurisprudence. The following three are the relevant but not one. Find the odd man out. A, classical theory. B, Roman theory. C, Greek theory. D, classical Indian theory.
Option D, sir.
Classical
Classical
Indian
Indian theory.
Now you tell me what is the wrong it is. You give the reason.
Classical Indian theory. There is nothing such theory, sir.
No, it is there, but I removed ancient Indian theory. I removed ancient and I put the classical. Asian Indian theory also there. Dharma. It is ancient Indian theory. Okay, now read anyone 57th question.
Question number 57. Different approaches towards the study of the jurisprudence. The following three are the relevant and but not one. Find out the odd man out. Option A, reformative theory. Option B, rationalist theory. Option C, medieval theory. Option D, modern theory.
C, sir. Option C. Medieval theory.
There is no medieval theory is there, but there is a modern theory is there. So option C is odd man out, but the rest of the three are relevant theories. Next, anyone can unmute and read 58 question.
Question number 58. 59 is sir. Next question. 58.
58.
Okay. 58 question number. Jeremy Bentham, John Austin, Solomon, Holland, Hurt, etc. Jurist and exponents or belongs to dash school. Option A, analytical school. Option B, historical school. Option C, realistic school. Option D, none of the above.
Option A, sir. Analytical school.
Analytical.
Analytical school, they are not belong because they are belong to analytical school, all of them, not historical school. And you read realistic school. No, there is no realistic school, realist school. Is it correct?
Yes, sir.
Okay,
Realist.
now the cursor I am showing it. The symbol I put it. What do you say the symbol?
Forward slash, sir.
Okay, you can say forward slash or slash. Synonym?
Or.
Oblique. Oblique.
Oblique. OBLIQUE. Another?
So jurist
By.
are ORR.
I want the word. Stroke.
And stroke.
STROKE, stroke. But the Professor Hussain students will not say neither the slash, nor the oblique, nor the stroke. A Polish language, virgule, VIRGULE. I repeat, VIRGULE, virgule. Okay, now next, go to the next. 59th question. Anyone can unmute and read.
Yeah. Question number 59. Jurist, founders, jurist, Varghese, founders,
Virgil.
Varghese, Vargil. Jurist, Vargil, founders, Vargil, exponents in part A, and their theories or works in part B match the following. Part A, option 1, Grosh. Sir, అదేంటి సార్?
Grotius Immanuel Kant.
Grotius, Immanuel Kant, Hegel. Second one,
Savigny Henry
Savigny
Henry Edmund.
Edmund.
Edmund. Oliver
Holmes.
Holmes, Carl Lewin.
Levin.
Okay, sir.
Montesquieu.
Augustine,
Montesquieu.
Comte. Okay, sir. Augustine on Comte Spencer. And part B.
Okay, tell me.
Philosophical, Virgil, natural sciences. Option B, historical school. Option C, realistic school. Option D, Heber, sociological school.
Yes. Now you tell me which one belongs to which one. Yes. At least use your, I don't give the option. If I give the option, no, you can easily make it out. No doubt at all. In different manner, but I want to give in this manner. And yesterday, subject to the correction I told you, Grotius is a Dutchman, but he's a Republican. And actually, he is not belongs to a realist school. No, he belongs to the natural school or philosophical school. Now I have given the hint. Now you tell me. Grotius belongs to
Natural school.
yeah. Philosophical school or natural school. Then Savigny and Henry and Edmund.
Historical school.
Yes. And Oliver Holmes, Carl Lewin, they are realistic school. And this Holmes and Carl Lewin belongs to which country? United States.
United States.
Montesquieu, Auguste Comte, Spencer
France.
is a sociological school.
Yes.
So now here you have given C. The correct answer. Grotius Immanuel Kant, Hegel, philosophical natural school from USA. Savigny Henry Edmund, historical school. Oliver Holmes, Carl Lewin, realist school. No, that is not USA. This is the realistic school is USA. Montesquieu and Auguste Comte and Spencer, Heber, and sociological school. Even Heber also comes under sociological school, not D. This come here. The D should come here. So that was the thing which I want to make it out. Okay, next. Read 60th question.
Question number 60th.
I quote.
I quote that the control over another person, yet not over his person in all respects, but over a single act of his which must be
Conceived.
conceived of subtracted from his free will and subject to our will, according to whom
I unquote.
okay.
I unquote.
I unquote definition is connected to.
Yes. Who said that quotation? And the definition is connected to what? Is it option A, Savigny and an obligation? B, Hugo Gracious and position? C, Bentham and right? D, Hobbes and duty?
Option B, sir. Hugo Grotius and possession.
Wrong.
Option D, sir. Hobbies and duty.
Wrong.
Then C, sir. Bentham and right.
Wrong.
I think. I think.
See, obligation, you read obligation. The control over the another person, yet not over his person in all respect, but over a single act which must consider the subtracted from his free will and subject to our will. It is an obligation means duty. Okay, 61st question. Then what are the types of obligations? Obligations of three kinds in general. Which one is odd man out? A, imperfect obligation. B, natural obligation. C, criminal obligation. D, civil obligations.
A, sir. Imperfect obligations.
Wrong.
Civil obligation, sir.
Natural obligation, B.
See, there is not be a criminal obligation, but there is a civil obligation is there.
Yes, sir.
And criminal obligation will not be there. But a civil obligation will be there. Suppose your father has taken the money and he died. And he is having a lot of property. Can the son will not be liable to pay the debts of the father?
Yes.
No,
Is
sir.
this-
Liable.
Yes, sir.
Property is
Liability,
is
that
liable.
is. Okay, now father has murdered. And after some time he died. Can a son will be put behind the bar?
No, sir. No. There is no criminal obligation.
No criminal obligation. Is it clear?
Yes, sir. Then what is imperfect obligation, sir?
Yeah, imperfect means there is no correct obligation would be there. For instance, a swimming pool is there and you are a passerby and a boy fell down and asking for the help. Please help me, help me. And you just pass on because there is no obligation on you to help him. The reason is you also don't know swimming. So imperfect obligation is there. And perfect obligation comes at that instance. Suppose you are a coach and a boy fell down and crying. It is your obligation, legal obligation that is. It is a legal obligation on you to rescue him. Because you are a coach, you are appointed for the training as well as the rescue. The legal obligation. And the moral obligation, suppose somebody comes to your house and asks for money or asks for some rice or leftover food. That is a moral obligation to give him. Is it clear?
Yes, sir.
So now let us see that who among four is not a natural person? And here, A natural person is a human being and is a real and a living person. B, he has a characteristic of a power of thought, speech, and choice. C, unborn, dead man, and lower animal are not considered as natural persons. D, the layman does not recognize idiot, company, corporation, ideal, etc.
Option B.
C, sir.
B.
A is a right answer, natural person. B also a right answer, natural person. And C also a right answer, natural person. What is the D? Why not the D is not a natural person? Tell me.
This is
Because,
artificial
sir,
person,
idiot-
sir. Company and the incorporation.
He's a legal person, sir.
Now they are
Company is a
recognized,
legal
but
person,
earlier they
sir.
did not recognize. So a layman does not recognize idiot, company, corporation, idol. I say ideal there. Idol. God, goddesses, you know it? Idol worship.
Yeah.
Do you know it or not?
IDOL. Sir, ideal is IDOL, na sir?
Yeah.
IDOL.
It is not
IDOL. This is the right answer.
IDEAL.
This is the right answer. But I wrote ideal, so it is wrong.
Yeah.
And see, Lord Venkateshwara we say, Lord Rama we say. Is it clear? Saraswati goddesses will say. But Maisamma and Pochamma, Saraka Samakkas, can you say Lord Samakka?
No,
No,
they will
sir.
say Tali. Maisamma Talli.
Maisamma Talli will say. But what do you say in English? We don't say
God.
God there.
Yes.
We say deity. D-I-E-T, deity Saraka. Deity Samak. Are you following me?
Yes, sir.
Yes, sir.
Yes. Because let us go to the 63rd question. Who is not a legal person? And here I have given A. Legal person is being real or imaginary whom the law regards as a capable of right and duties. B. Legal persons are also termed fictitious, juristic, artificial, or moral. C. In law, idiots, dead man, unborn person, corporation, companies, idols, etc. are treated as legal persons. D. The legal person perform their function through neutral person only.
D.
B, sir. Option B.
Why option
Option
D
D.
is not legal person? What is the wrong?
Fictitious. Fictitious, no, sir.
No,
Yes, sir.
Artificial, not existent.
no. B is the right answer. Even a fictitious also will come. Juristic, artificial,
D, sir.
and
Option
moral.
D.
D is the wrong
Option
because
D, sir.
I said neutral persons. It's not a neutral persons. Natural persons only.
Yes.
It is not a neutral persons. It is a natural persons only. So
Yeah.
this is the critical way of examining you because you can easily make it out who is the legal person if I could give the only one answer for them. But I gave the different right persons and the wrong one you have to find it. So your sharpness will be there. By looking at it, you can easily shoot out, yes, the wrong goes here. Okay,
Sir,
now next.
submission, sir.
Read anyone?
Sir, one submission, sir.
Yes, please.
Sir, in exam also they will do like that only, sir, as you have
I am training you
shown
in
the-
all aspects.
Okay,
I'm not training in one way only.
okay, sir.
What is jurisprudencia? What is prudentia? Who is the father of? Who is the new? Is a routine questions. But a critical angle I am giving you because you know how to shoot it. In a negative way, it is difficult to shoot. For instance, in moot court competition, did you participate anytime moot court competition?
No, sir.
No, sir.
There
We are
is an
Kannada
exam
people.
is there moot court for you. And in the
We are
exam that
Kannada
you got to argue from the both the sides. Plaintiff side
No,
as
sir.
well as the defendant side.
No, sir.
You don't have in the last year. I mean,
Sir, we
third
are
year,
ethical Kannada
there is a
guys.
moot court is there. I don't know whether you attended or somebody proxy you sent it. And there,
No, sir. We have attended, yeah.
No, sir.
you have to
Not we are
argue
in
from the both the sides. But when you argue from the plaintiff side, it is very easy to argue. But when you want to argue from the defendant side, it is difficult to argue. So now I am training you not from the plaintiff side. I am training you from the defendant side. So that when you are good in the negative argument, you are more good in positive argument. Is it clear?
Yes, sir.
Yes, sir.
64th question. I quote, every man has a property in his person. Every individual has the right to preserve his property. That is his life, liberty, and estate. Iron Court. According to whom? Robinson, B. Blackstone, C. Hatt, D. Locke.
Blackstone.
Blackstone, sir.
Yes,
Option
it is the
Blackstone.
Locke. The Locke is the right answer. I did not ask you what I committed a mistake here. Because you can easily make it out because I trained you. I trained you to the angle that you want to make it out. So that's why I did not ask you what mistake I have committed. Because it is a glaring mistake, you could see it. Now let us come to the next point. Yes, read the 65th question.
Question number 65th. The main kind of encumbrances or dash all
Encumbrances.
are dash all three but not one. Which one is correct? Option A, lease. Option B,
Servitude.
servitude. Option C, security. Option D, all of them.
What is servitude, sir? Option B.
Servitude means, suppose if you have purchased a house. When you purchase a house, the house owner should have to, the seller should have to show you the way you have to reach to the roadside. Number one.
Yes, sir.
And they are enjoying that right to light, right to way, right to passage, right to water. If they are enjoying it, when you are selling it, and that is called covenant. The covenant also comes with that. Suppose when you purchase the cow, if the cow is having the calf, and when you purchase the cow, calf comes automatically. Is it clear?
Yes, sir. Yes, sir.
So that is called servitude. Easement. So here
Easement,
present
yes, sir.
encumbrances are
All of the above, sir.
all of the above is the encumbrances. A lease, a property is free from lease or mortgage or a gift or sold out. Servitude, whether such a thing is there or not, it is an encumbrances. Covenant. Security is the encumbrances. So 66th question. Right of way across the land of somebody. The right of light and air, etc., known as. I already gave the answer.
Yes, sir. Easement.
That is servitude.
Yes, sir.
Options you have to choose it, not the one. Of course, it's the easement, but from the options you have to choose it.
Yes, sir. All of them, sir.
No, lease not, because lease is not a servitude. The example which I given, right to light, right to across the land, right to air, right to passage, it comes only under the servitude. So
Okay.
67th question, anyone can read and
And security should also be there, sir. Once I purchase any land, I need
here
security.
security in the sense you give your property as a security to the bank. Is it not an encumbrance? If any person wants to buy it, is it not an obstacle to him? Your title is not free from the hurdles. Encumbrances means free from any hurdle. Clear cut transaction.
Yes,
See, when
sir.
you are buying
Now
the
I got it.
property and you go to the registry and ask for the encumbrances certificate, EC, whether it is mortgaged, whether it is sold to somebody else, and everything would be recorded over there. And say EC should be required, and that to be not old, latest EC. EC
Yes, sir.
means encumbrances certificate. Okay, read
Yes.
that 67th question.
66, sir. Or 67.
67.
Okay. Yeah. Theories of property. Many theories have been put forward to explain the origin of property and its justification. One among them not belong to option A, historical theory, option B, positive theory, option C, negative theory, option D, psychological theory. Sir, option D, sir, psychological theory.
No, it is there. Psychological theory is
Yeah,
there.
means negative
See,
theory, sir.
sir,
There is no
negative
such
theory.
Negative
Negative
theory is
negative
not there.
theory. There is no such theory.
There is a positive theory is there, but negative theory is not there.
Yes, sir.
And a historical theory is there. And what I don't ask what I committed a mistake, because you already read A, historical theory, B, positive theory, C, negative theory, D, psychological theory, because you are trained in a such a way.
Yes, sir.
So now I am training you in any angle. The prey should not run away from your target. You know what is prey? P-R-E-Y, prey?
Yes, sir. Shikar,
Yes, yes. The aim
object.
to it. For instance, you go for the forest and your prey would be there. You want to kill the stag, antelope, or barasinga, or something like that, which can be, we will eat. And the next comes to the 68th question. An offense which is pursued at the discretion of the injured party or his representative in a civil injury. Offenses which are pursued by the sovereign or by the subordinate of the sovereign are a crime. All absolute obligations are enforced criminally dash. Who said? Puchta, Austin, C. Savigny, D. Salman.
Savigny, sir.
Wrong.
C, Savigny.
Salmon, sir. Option D.
C, Savigny.
Wrong.
Sir, A. Pushta.
Austin.
Wrong.
Austin.
Austin said. That is said by the. Yes, anyone can unmute and read.
Question number 69. When a person has committed a wrong, he is said to be A, not liable, B, liable, C, wrong done, D, offense committed.
Sir, C. It is a wrongdoer. WRONGDOER, sir. It's option C, wrongdoer.
Offense committed, sir. Option D.
Yes,
You
sir,
have to
option D,
choose
offense
from the what the four options I have given.
Offense committed. Option D.
Sir, A, sir, not liable, sir.
When a person has committed a wrong, he is not liable.
He is liable.
Is
Liable.
sir.
Then what the exact
Then what-
answer?
Liable.
What is the, then what
You
is the
are
difference between
not
liable
to
and
frame your own option. You have to select from the given option.
Appropriate one.
Yes, relevant to answer. Even the
Liable,
very relevant, more relevant answer you have to give it. Is it clear?
Yes, sir.
Okay. Suppose civil cases, a person who has committed a wrong is called wrongdoer. WRONG-DOEER. Wrongdoer. Suppose if a person committed in the criminal wrong, what do you say? Sir, wrongdoer.
accused?
Accused.
No.
Offense committed.
No.
Criminal.
No. Perpetrator.
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 Yes, sir. Got it.
You should have to speak like a Professor Hussain. That's my intention. Okay, now let us come to the 70th question. Which statement is wrong among the four? Number one, A, though intention and motive are very close to each other, they are the same. B, motive is called the ulterior intention or intent. C, it is seldom that a man commits a wrongful act for its own sake. D, the wrongdoer has some end in his mind which he tries to achieve through his wrongful act. Which statement is wrong among the four?
C, sir.
Read once
Option
again.
C, sir. It is seldom that a man commits a wrongful act for its own sake.
The wrongdoer has some end in his mind because he wants to achieve the target. He wants to steal the money, or he wants to steal the property so that he can sell it and he can get the money. Of course, it will when participant in the 5 minutes, it's no matter. Yes. So the right answer is, I will show you because it is gone. Okay, first I will say okay. Then I will share the file. Is it clear now? Did you see my file?
Yes, sir.
sir.
Yeah, now I say two words here. One is intention, another is motive. So, though intention and motive are very close to each other, they are the same, not they are the same. So, they are the different. They are not the same. So, I removed the not. They are not the same. I removed the not, not, not from here.
So they are different from mens rea, sir.
No. See, intention means malice. Malice means you have the bad intention. When you have an intention, ulterior intention is motive. The motive may be the bad or the motive may be the good. In the both the way, you will be punished depending upon the nature of the offense. If you have the good motive, even though also it is an offense. For instance, if a person is taking the ram or a goat or a sheep for cutting, slaughter, your good intention is that you should not to kill the animal because you are a Maneka Gandhi disciple. So you don't want to kill that sheep will be slaughtered. So you want to stop him. Your intention is good, but it is a good act. Is it a good act? No.
For some, it is a good act.
No, sir.
See, for vegetarian, for non-vegetarian, it depends upon it. Suppose if you leave India, you are supposed to eat beef because all the places in other than India, beef is sold and that to be costly. And here, beef is costly and goat is a cheap rate. Mutton is cheap rate and beef is costly. And I never eat neither mutton nor beef. I eat fish because fish is a very cheap and a good also. So here they are both different. Intention is the beginning of your idea and the motive is the ulterior intention is your motive. So that is the same thing which you say. Motive is called the ulterior intention or intent. It is the seldom that a man commits a wrongful act for its own sake. Naturally, a man will not commit for the own sake. No. He will not commit unless until if he is starving, then he commits the offense of stealing the piece of loaf or bread at that instance only, but mostly for the external desires, a man wants to make it out. The last one is the wrongdoer has some end in his mind. That is a target is there and which is tries to achieve though his wrongful act. So these are the things of the today class and tomorrow class. And what is the next tomorrow class? Say.
Continuation of jurisprudence, sir.
2 days only jurisprudence.
Okay.
Constitutional law 2 days, which I did it. Jurisprudence 2 days, yesterday and today. What is the next?
Public international law, sir.
I shown on the screen.
Public international law.
Public international law. Read and come to the class. Make the class as a participatory class. Here in Tanzania, today is a public holiday. We will say Sabah Sabah. Sabah means is the Arabic word. How much Sabah means?
Friend.
Daha means temple.
Meeting.
Sabah.
Print, sir.
जनगण मन अधिनायक जय हे
भारत भाग्य विधाता
पंजाब सिंध गुजरात मराठा
द्राविड उत्कल बंगा
विंध्य हिमाचल यमुना गंगा
उच्छल जलधि तरंग
तव शुभ नाम जागे तब शुभ आशीष मांगे गाहे तव जय गाथा
जनगण मंगलदायक जय हे
भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
जय हिंद। सारे जहां से अच्छा हिंदुस्तान हमारा।